In this video, I want to talk about a long-running unauthorised development case involving Meath County Council and a couple, the Murrays, who built a massive house in 2006 in Bohermeen, Navan, County Meath. The case has been running for 18 years and it's been in the High Court a couple of times, it's been in the Supreme Court. There has been injunctions, notices of motion, all sorts of legal actions. The couple in question did undertake to vacate the house to allow Meath County Council demolish the house. The house is over 500 square metres. That's 6,300 square feet. And to put that in context, a 3-bed semi is 1,200, 1,300 square feet. So this house, 6,300 square feet, is probably the size of 4 or 5 3-bed semis. But it is to be demolished, it's supposed to be demolished. Meath County Council are looking to do that now, and the High Court, or the couple, have been back to the High Court with what has been held to be, by the High Court, to be a frivolous and vexatious action. So everything has been cleared, the way has been cleared for the house to be demolished, but they've made another planning application, retention application. This saga is running for, since 2006, 18 years. So that's what this video is about. The High Court has dismissed a couple's, what the High Court has described as a vexatious bid to prevent demolition of their Meath home that they built 18 years ago without planning permission. The couple are Chris and Rose Murray. They built a 588 square metre home 18 years ago, despite being refused planning permission. And in case you're wondering what a 588 square metre home looks like or what size it is, it's actually 6,300 square feet or thereabouts. And if you consider that the average 3-bed semi is around about 1,250, 1,300 square feet, then this 6,300 square feet is a big house. It's a very, very impressive house. The legal proceedings have been going on for 18 years. Plumber Chris Murray and his wife issued legal proceedings despite earlier agreeing to vacate this family home so that it could be demolished in September 2022. They claimed that new information came to light. That means the court should set aside the agreement and earlier court orders requiring them to vacate. This case was even in the Supreme Court. In May 2017, the Supreme Court upheld High Court orders for them to remove any unauthorised development from their land at Faughan Hill, Bohermeen, Navan, County Meath. The Supreme Court in 2017 gave them 1 year to vacate the property, which the court said had been deliberately constructed in flagrant breach of the planning laws. This order to vacate was not complied with, and Meath County Council then brought a motion in March 2019 seeking for the Murrays to be brought to court over alleged contempt of a court order. The motion did not proceed as the two sides reached a settlement agreement in September 2020. This settlement agreement involved the Murrays agreeing to vacate the property within 2 years to facilitate its demolition by the council. 3 days before the expiry of the period to vacate, the Murrays issued a fresh case against Meath County Council. Their action sought a pause to the High Court and Supreme Court enforcement orders and injunctions preventing the local authority from taking any enforcement steps. They claimed that there was new evidence relating to land sterilisation agreements made by their land's previous owners. They claimed this and a recent High Court judgment invalidated the planning refusals for their home. The council asked the court to dismiss the case. The background was set out in the judgment of Mr. Justice Conor Dignam, who said he was compelled to conclude that the Murrays' claim should be struck out. He agreed with Meath County Council that it was frivolous, vexatious and an abusive process. He noted that judicial review proceedings challenging a planning decision must be brought within 8 weeks of the decision unless the High Court grants an extension on the basis of a council allegedly, deliberately or fraudulently concealing information. The Murrays did not bring such a challenge, the judge said, as he dismissed their case. The Murrays were refused planning permission in 2006. but they proceeded to construct a home considerably larger than that for which they had sought permission. The council wrote to them in 2007 requesting removal of the unauthorised development, which led to the Murrays seeking permission to retain the build. The council and An Bord Pleanála refused this application, and another later one seeking permission to demolish parts of the house and retain the rest. Meath County Council initiated its enforcement proceedings in June 2007. And bearing in mind that this is November 2024, this is clearly a long-running saga. As part of their soon-to-be-dismissed case, the couple said that they had applied again for planning permission for their home. The judge noted the council and An Bord Pleanála rejected the application before he delivered his decision. However, he was told the Murrays had made a further planning application after this. That's what happens when you have an unauthorised development. You have significant problems, to put it mildly. This is a massive house. It's a very, very impressive structure. It would be a shame to see it demolished, but the planning laws are there for a reason, and this case has been well aired by the Murrays in the High Court, in the Supreme Court, in the High Court again, and it is where it is. Hope you liked the video. If you do, I'd appreciate if you hit the thumbs up button down below, and you may be interested in subscribing to my YouTube channel. Thank you.